Finance and Policy to order. It's Wednesday, March 23rd, 2022 at about 6:17 p.m. First order of business will be Senate File 3933. Senator Chamberlain, to your bill.
Thank you, Mr. Chair and members. I do have an A1 authors amendment.
Senator Chamberlain, will move your A1 authors amendment. Is it all those in favor of the A1 amendment signify by saying aye. Aye. Those opposed, nay. Motion carries. To your bill, Senator Chamberlain, as amended.
Okay, thank you, members and Mr. Chair. We've been talking about this issue of social media for a few years now. Last year, Minnesota became the only state, I believe, the first state to implement a grant program to start educating children and supporting people across the state about the proper use, the best use of social media, both the pros and the cons, the good and the bad. And there's a lot of good, but there's a lot of bad to it. So you'll see them testifying shortly. They have been working on this for a couple of years. Last year, we got a bipartisan bill passed to support those efforts to help protect kids and inform people of the safe, proper use of social media. Well, this year, something else came to our attention. Representative Kristen Robbins in the House was working on a different piece of legislation, an algorithm bill. The proposal basically would prohibit the use of algorithms by social media companies, and there's some details in the bill I'll talk about in a second, that would prohibit targeting those under 18 years old. It does not do anything with content. It's not a First Amendment issue. It's about targeting kids under 18 with algorithms. Now, social media companies do more than just publish content. I was given a note and was reminded that their job is to get eyeballs onto stuff so they can monetize that. So by their own admission, they give people the power to build the community and bring the world closer together, which sounds great, and it is to an extent, but that means they target individuals with data and algorithms to bring eyeballs to particular things. Now, we spend a lot of energy and time protecting kids, minors, from a lot of different things: alcohol, tobacco, drugs, to name a few. Those are easy because they're understandable, they're physical, they're tangible. They're right there in front of us. Well, algorithms are neither physical, tangible, and you can't see them. And people don't easily understand that. But I will submit to you, while they are not tangible, physical, or easily understandable, it is just as harmful. They create hazards and create potential harm for kids using social media. So that's what we're trying to do, is protect kids from these things, seen and unseen. I would also say the algorithms might even be a little more harmful because that invisible thing gets into their mind and just wreaks havoc on their lives. Now, not all kids have these challenges, but a significant number do. So with that, I will briefly run through the bill. As you can see, it's only a page and a half. The amendment adjusted a few things. It has the typical definitions of account holders and operators, social media algorithms, what a platform is. We did change the word at the request of some other people. We did tighten this up and changed user created to user generated throughout the bill. Secondly, the next largest change was simply at the end on page 2, we include exceptions. We increase the number of exceptions, and the amendment will show that in line 1.12, we increase the number of exceptions. So what this does then The heart of it is sub 2, prohibition of social media algorithms that are with account holders, with those companies that have more than 1 million account holders. Operating in Minnesota is prohibited from using a social media algorithm to target user-created content at the age, those under age of 18. That is the heart of it. Gives kind of a cause of action, so that this will be going to civil law. And you can see that there. But this does not cross swords with federal law 230. The law came into being in the late 90s. It hasn't changed. A lot of things around here have changed in our culture and environment, even in the last 5 years. So I urge members to support this effort to protect kids from this harm, just like we would with tobacco, alcohol, or anything else, and help start something new and help some kids recover. Thank you.
Thank you, Senator Chamberlain, and I will go to a testifiers now, and keep in mind, testifiers, if you could stay to 3 minutes apiece. We'd like to get home sometime tonight. So first we have Bryn Austin from the Harvard Medical School of Public Health. I see your remote. Miss Austin?
Thank you.
Please state your name.
Evening.
Yeah, for the audio record, and continue with your testimony.
I'm Dr. Bryn Austin, professor at Harvard Medical School. I'm here to share research on the negative effects of social media algorithms on adolescents and their link with eating disorders. Nearly 30 million Americans will have an eating disorder in their lifetime, and nearly 2 million children alive today will have an eating disorder before their 20th birthday. Eating disorders are among the most deadly of any mental health condition, killing over 10,000 Americans every year, or 1 person every 52 minutes. Nearly 500,000 Minnesotans will have an eating disorder in their lifetime, and these conditions cost the Minnesota economy $1.1 billion each year. Almost 2/3 of 13 to 18-year-olds and more than 1 in 10 8 to 12-year-olds use social media daily. Image-based platforms like Instagram can be very harmful in their effects on teen mental health, particularly for teens struggling with body image, anxiety, depression, and eating disorders. Imagine a teen likes a post about an extreme diet, a type of content known to worsen eating disorder symptoms. The algorithm will then amp up this type of post in their feed so the teen sees much more of this type of harmful content. This includes commercial content promoting a hyper-focus on extreme thinness and unrealistic weight loss through dangerous and unproven means. Even more insidiously, algorithms identify content posted by troubled users promoting extreme eating disorder behavior and then leverage it for profit by placing ads for mainstream teen brands adjacent to this extreme content, knowing it'll boost engagement. In effect, the algorithm is expressly designed to ensure this teen's feed is filled with a continuous stream of toxic content. State governments have the power and responsibility to hold tech companies accountable by ensuring their algorithms do not harm young users. Thank you.
Thank you, Dr. Austin. Next, we'll have Ms. Myers from Live More, Screen Less. If you can please state your, and we have, I see Ms. Hampton from the same organization. Please state your name for the audio record and continue with your testimony.
Thank you. My name is Catherine Myers. Thank you, Chair Dahms and members of the committee. I'm the co-founder of Live More Screen Less, a Minnesota-based nonprofit. Thank you to the chief authors in the Senate for putting the bill before this 2022 legislative session. Consider this. In 2017, Netflix CEO Reed Hastings declared the streamer's biggest competitor was sleep. And he replied, "We are winning." The game he is winning and playing is capturing and holding our attention. Whoever gets the most attention is the winner by billions. As a former high school teacher, I worked hard to build relationships with my students to earn their trust and gain their attention. I don't think you could find a high school, maybe middle or elementary teacher anywhere who is not struggling against the pull of technology to capture their students' attention. Our children, teachers, and parents are losing the battle, and big tech is winning. It is all by design. Every like, share, comment, interest, location, video, watched, video liked, or even the time spent is a treasure trove of data collected for one purpose: to win our attention. The algorithms that feed our next Netflix show, our Instagram ads, or even our news feeds are all intended to win our attention. In a recent New York Times article titled "How TikTok Reads Your Mind," Ben Smith revealed that TikTok optimizes for time spent on the app. Let me repeat, time spent. The more time we spend on apps, the more money in big tech hands. Algorithms are feeding an attention economy. Attention economy was created or cited by former Google exec Tristan Harris, and now founder of the Center for Humane Technology. We are not paying for social media with currency that we count in dollars. We are paying with currency far more rare, precious, and non-renewable, our minds and our attention. And for young people, this is costing them lost time from other healthy activities, like time outdoors, or being face-to-face with friends, or hanging out with family. U.S. Surgeon General Vivek Murthy, in his 2021 Protecting Youth Mental Health, reports that research exists linking time spent on social media to mental health challenges, such as anxiety and depression. Additionally, Sue Abderholden, Executive Director from Minnesota NAMI, has submitted to the committee further research findings to this committee. Whether you hear it from a mental health professional, a nationally appointed physician, university researchers, or young people themselves, the message is clear. Big tech, persuasive and manipulative design is prioritizing their business strategy and money-making models over the well-being of our children. Thank you.
Thank you. Ms. Hampton, please state your name for the record and proceed with your testimony.
Hello, my name is Marie Hampton. I'm the co-founder of Live More, Screen Less. I'm also a parent of 2 boys. Thank you, Senator Dahms, and for the committee members for inviting us to present this evening. Last year, Minnesota unanimously passed digital well-being legislation, the first in the country, to create a law supporting digital well-being by raising awareness of the issue and providing education. This law supports awareness and education activities, including an online resource library available to all Minnesotans, parent communication, a train the trainer for adults who work with young people, and peer education. As our organization listens to high school and middle school students, we're finding they're ready to share the benefits and the drawbacks of digital media, as well as how they're working towards solutions. Easily identified and universal benefits include communicating with friends and family, entertainment, learning, inspiration, and creativity. The drawbacks are multifaceted and layered. Here are a few quotes from young people we've spoken to about the drawbacks they are experiencing. I isolate with my phone a lot. I can get sucked into it and strain my eyes and spend all day on my phone. I'm prone to headaches, so gaming for too long can hurt. There's bad stuff online I'm exposed to against my will. Hate, discrimination, and more. As lawmakers, you are tasked to ensure laws are in place that honor our Constitution while ensuring our greatest treasure, our children, and their right to a happy and healthy childhood is not diminished tarnished, or denigrated by the greed of Silicon Valley. Big tech must be held accountable. As we heard Frances Haugen's account of Facebook's internal research, they have the data. They have the power to change their business model, to be transparent about the impact of their products, and to support parents and young people so they can make informed decisions and to aid researchers in identifying problems and solutions. Senators, thank you for your time, your consideration, and your fight to ensure the health and well-being of children so they can become the winners. Thank you.
Thank you for your testimony. Next, we go to Ms. McKenzie with Entertainment Software Association. You're remote. Please state your name for the record and proceed with your testimony.
Thank you. Good evening, Chair Dahms, Vice Chair Howe, and members of the committee. I'm having a bit of technical difficulty, so please forgive me for not having my video on. My name is Maya McKenzie, and I'm Technology Policy Counsel for the Entertainment Software Association. This is the trade association representing video game publishers and console makers. The video game industry has long supported efforts and complied with laws that keep children safe online, and we appreciate the sponsors' well-intentioned legislation. However, it's important to note that Senate File 3933 would frustrate that goal of keeping children safe online. This bill is overbroad in scope, would stifle community building aspects of online gameplay, and unnecessarily subject video game publishers and console makers to frivolous litigation. So for those reasons, we respectfully oppose Senate File 3933. First, this bill is drafted as overbroad in scope as it would apply to any online platform and any content generated by said platform's users. Many video game publishers and console makers would be considered operators of a social media platform under this bill, as their products or services contain certain online features that collect users' personal information and allow their users to create, view, and share their content with others. Further, any content generated by a user in a video game would be regulated by this bill. Now, many gamers memorialize achievements by capturing the moment via screenshots or recording achievement moments during gameplay. These screenshots and video clips, though they may not feature a child's likeness or name, would be within the scope of user-generated content. Now, because this bill captures such a broad section of online activity, including gaming, the prohibition on the use of algorithms would stifle community building features essential to gaming. In some instances, an algorithm is used to determine which content a user sees. So instead of displaying gameplay from one of the thousands of games that exist, an algorithm might narrow the field and only display gameplay from games that a user is interested in or has played in the past. Video game players share gameplay content to highlight their achievements and build camaraderie. 77% of gamers play with others online or in person, and 74% of parents play games with their children on a weekly basis. Prohibiting the use of algorithms that aid in aligning content with users' interests frustrates the community building aspect of games that unites gamers in an increasingly disconnected and virtual world. And finally, Senate File 3933 proposes inoperable and unclear legal standards regarding the use of algorithms. This bill would prohibit the use of an algorithm that prioritizes and directs prioritized content to a user, but does not provide clarity on what prioritization means. In addition, this bill would implement a constructive knowledge standard for determining the age of users who can and cannot be targeted via an algorithm. This standard deviates from the actual knowledge framework for determining age under COPPA, which is the federal children's privacy law. The actual knowledge standard gives operators clarity on when increased protections are necessary. And without this bright line rule, an operator would be in the position to apply heightened restrictions to all users to avoid a risk of noncompliance, which would include altering the delivery of products and services to adults. Given the unclear legal standards set forth by this bill, a private right of action would create unnecessary liability for video game publishers and console makers. And for these reasons, we respectfully oppose Senate File 3933. Thank you for the opportunity to testify today. The video game industry is a partner in protecting children online and open to collaboration on workable, clear solutions. And I'm happy to answer any questions.
Thank you, Ms. McKenzie. And now we'll go to Mr. Zabo with Net Choice. Please state your name for the audio record and proceed with your testimony.
Thank you, Mr. Chairman, members of the committee. My name is Carl Szabo. I am Vice President and General Counsel of NetChoice. I'm also an adjunct professor at George Mason Law School. Now, we've heard a lot. First, the comparison to cigarettes. It's bombastic, but it's not accurate. Name a single person who thinks smoking improves life. Can't find them. Well, the sponsor himself acknowledges that there is, quote, a lot of good from the internet. It provided a lifeline for our children throughout COVID and is still being used today in my kids' schools. Perhaps a better analogy is food. There's good food and not great food, like fast food. Throughout the Minnesota State Fair, it's hard to find something without butter or deep frying it. But we don't ban 16-year-olds from buying this. But that's what we're doing here for social media. We're removing personal choice and responsibility, and it seems as though we should be criminalizing essentially making good tasting food. We heard a lot about Netflix. Well, they're not covered by this bill. And it sounds very similar to the complaints we've heard about television for decades. Oh, it's destroying our sleep lives, it's dominating us. Second, what is an algorithm? Well, the bill doesn't define it. What is it? It helps me find the content I'm looking for. It also helps to stop unwanted things from reaching 17-year-olds. And we heard from the sponsor that don't worry about the First Amendment. There's no limitation on content. But the Supreme Court back in 1988 in Booz versus Berry said prohibiting public discussion of an entire topic in and of itself is a First Amendment violation, and that's what we're talking about right here. Now look, I'm a parent. You're probably hearing my kids in the background. It's bath time. And parenting in the 21st century is hard. My wife is a child therapist. And I suspect my parents felt something similar with the advent of cable television as I do to the internet. My grandparents for TV, for their kids, and my great-grandparents for radio. So this feeling of helplessness is nothing new. And as a parent, I welcome assistance. But I don't want the government deciding for me what is best for me and my family. And that's what we're talking about with SF 3933. Now, there are many problems with the bill, as well-intended as it is, but it's becoming increasingly clear that as well-intentioned as it is nowhere near ready for prime time. There are First Amendment problems. There are equal protection problems under the 14th Amendment. There are Commerce Clause problems, as well as a myriad of unintended consequences. And even with the amendments that were introduced today, that actually exacerbates several of the First Amendment problems. So on the First Amendment problems, there is the case on point, ACLU versus Ashcroft, where Congress tried to essentially outlaw showing pornography to children and those under the age of 17. Well, that was unconstitutional. That's blocking pornography. This bill is about blocking any content that's recommended or sorted. COPPA, the federal law that was unconstitutional, was for those under 17. This is under 18. COPPA was harmful to minors, which was narrowly defined. This includes terms like algorithm and targeting, neither of which are defined. There's also the 14th Amendment, equal protection clauses, as it impacts every citizen across the country and every business across the country. There are dormant commerce clauses because you're reaching across your borders. And then there's the unintended harms because you can't block spam or porn or fraudulent content as much as the amendment seeks to do so because it includes vague and not clear terms. It would also impede the ability of Yelp to simply show restaurant reviews based on location or Best Buy showing you products that you might be interested in. For a myriad of reasons, this bill is not ready for prime time, and we ask you not to advance SF 3933. And I welcome any and all questions you may or may not have.
Thank you, Mr. Szabo. We will now go to Mr. Dyers with TechNet. Please state your name for the audio record and proceed with your testimony.
Yes, good evening, Mr. Chair, members of the committee. Tyler Dyers with TechNet. I'm the Midwest Executive Director, represent about 90 of the most innovative companies on the planet. I'm here before you in opposition to this legislation. Now, look, the internet runs on algorithms, and this bill seeks to ban algorithms on social media for Minnesotans who are under the age of 18. Algorithms are used every day in our life. Every one of us today has encountered an algorithm, and it likely made our lives easier. And I think we would all agree that we appreciate the conveniences that they provide, whether it's GPS assisting us to get from point A to point B, or our phones helping identify our faces to unlock our phones. But when it's used in the context of social media and teenage use, we automatically associate algorithms with being bad, but only if they're being used by the private sector. And I noticed in the bill that government has a special exemption, declaring government user-created content is permissible, but when it's used by anyone else, it's deemed nefarious. There are many beneficial uses of algorithms, as Carl mentioned, that would be greatly impacted should this bill become law. Social media algorithms are a way of sorting posts in a user's feed based on relevancy instead of published time. So in the context of social media, algorithms are built to essentially learn what our preferences are as opposed to when they are posted. So if you're a 17-year-old in the state and you're aspiring to be the next Joe Nathan and you love baseball, instead of being shown videos on how to throw a changeup or a curveball, now you'll be served videos on how to build a birdhouse. Not to mention, this bill would bifurcate social media platforms. So if enacted, the bill would force companies to create a platform for those over the age of 18 and one for those under the age of 18. However, in order to comply with the requirements laid out in the bill, my members will have to collect more personal information on its users to monitor their age to ensure that they are under the age of 18 and to track their precise location, even though many of them may not be doing that, to make sure that they are indeed in Minnesota to risk or to fend off any potential liability. So at a time when this body is debating issues like student data privacy and general online privacy, it seems to go in the wrong direction. Lastly, it is great to hear from the Live More, Screen Less folks. I mean, the whole purpose of the $1 million grant that was provided last year was to address issues that the sponsor had mentioned, such as suicide prevention, cyberbullying, internet safety in general. However, I was a little surprised to hear in the testimony that there was no mention of how the program was going. How is the money being spent? Is the program working as intended? Or perhaps the group needs more funding. All of this does not mean our members are not aware of the potential pitfalls of online activity, which is why our members have invested in resources and tools for parents on limiting time and other various protection elements, including comment filters and account privacy settings. So for those reasons, we ask you to not move forward with this bill. And thank you again, Mr. Chair.
Thank you. From Senator Chamberlain, any comments, or we will go to member questions?
Well, I'm going to enroll at George Mason University, if that's where Mr. Zob is from, because I'm sure I can get in based on that kind of constitutional analysis. It's just all over the place. First, this bill does not address First Amendment issues. If it does not talk at all about content, nothing. There's no banning of content. Zero, nada. Secondly, if someone under 18 wants to go somewhere and like something, look at something, then they can get access to it. What we're talking about is simply targeting youth. These people do it all the time, just like they did with cigarettes and booze and everything else. What they are suggesting is we should give the 16-year-old the keys to the car and open the liquor cabinet and have at it. That is what they're suggesting. This stuff is designed to get your attention, keep it, and burn your brain. That's exactly what it's done. They can't minimize it. This bill has nothing to do with blocking content or censoring it. It has everything to do with protecting kids from being targeted. It's very narrow and very focused from being targeted. So it's not blocking. So the video game issue, they can, if a child at 16 and a parent allows it, they can go play the video game and they can get access to that video game. It doesn't stop that. But the child and the parent have to choose it. Finally, as far as choice, the parents have choice. They don't. Because if that kid is in the room, they're being attacked by this stuff. So the parent doesn't have a choice to say, I'm not taking that algorithm. So this is not the wide-ranging constitutional challenge. It's just saying don't target the kids just like we do with cigarettes and booze and other advertisement. So members, this passed 15-1 in the House Commerce Committee. It passed 15-0 in their Judicial Committee. I think there's bipartisan support here. I think we can understand and bury the political swords, as it were, and look at what's really happening here. We're not saying get rid of the internet. We're not saying get rid of that stuff. We're saying we need a little common sense, a little help from the other side to help protect kids. And this is all doable with the current technology and with what they're doing now. So thank you very much for the time.
Members, any questions? Senator Kent.
Thank you, Mr. Chair. My first question is, did I understand that this bill is going to go to civil law next?
Yes, that's
Okay.
the next stop.
Okay. And Senator Chamberlain, I want to thank you because I agree with you. This is very important, and we all want to make sure that we're keeping our kids safe. And I want to thank Representative Robbins for her leadership in this area too, because I know she's worked hard on this. And to the leaders from, make sure I get it right, Live More, Screen Less. As a mom, thank you. I mean, I hear what you're saying. Because I believe in this and because I support it, and because I spent time years ago working on the student data privacy bill, and I have firsthand experience of how complex this can be, I want to make sure we get it right. And I appreciate the amendment and the, trying to do the carve-outs and make sure they're right. I want to offer a suggestion.
Sure.
We created the Legislative Commission on Data Practices a number of years ago, specifically because one of the things we know is that 201 legislators in the heart of a session have a hard time dealing with the very technical details of a world that none of us can fully appreciate. And the Legislative Commission on Data Practices was created to have time to bring in the experts, the people we trust, and to make sure, because as I said, I want to make sure when we do this that we do it right. So that is my concern, is that we don't try to rush this through and push something that is not going to work and be effective in keeping kids safe in a way that is meaningful. So that is my comment and my advice, having served and worked in that area some. And I wish everyone well in coming up with a successful solution to keep our kids safe.
Appreciate that, Senator. Yes, thank you.
Senator Chairman. Oh, Senator Port. My brain shuts down after 6
all right.
o'clock, so Senator Port.
Thank you, Mr. Chair, and thank you, Senator Chamberlain, for bringing this topic forward. I think, I have an 8-year-old and an 11-year-old. This is the reality of the world that they're growing up in, so I'm glad we're having the conversation. I think it's a really important conversation to have. One question I have on the subdivision 2, I think it's, well, before the amendment, it's like line 2.3. It's no, not to use the algorithm to target user-created content. Is there, or could we talk about, as this moves forward, also including ads, algorithms that target ads as a piece to it? As a parent who has kids who are on social media, there's also, targeting ads to kids, and what does that look like?
Sure.
It feels like an opportunity there to
Absolutely.
broaden that conversation.
Senator
Sure.
Chamberlain.
Yeah, sure. Thank you, Mr. Chair. Yes, Senator Port, and thank you, Senator Kitt. Absolutely. Yes, thank you.
Seeing no other questions, I will renew the motion that Senate File 3933 be passed as amended and re-referred to civil law. All those in favor signify by saying aye. Aye. Those opposed, nay. Motion carries. Senate File 3933 as amended is on its way to civil law.
Thank you, members.
You want to do it from there? Wherever's fine.
Senator Howe, welcome to Senate File 623. Do you have any amendments on that?
No, I don't.
All right, perfect. To the bill.
Members, Senate File 623 is a bill for the city of Sauk Rapids to allow them to provide a liquor license to sell on-site intoxicating liquor to a concessions contract in their Bob Cross Regional Park. That's all it does. It gives the city of Sauk Rapids the ability to issue a on-sale liquor license.
Pretty simple. I don't see, do you have anybody that wants to testify, or is there anybody that wants to testify for or against the bill? Not seeing any. Any questions from members? Where does this go? All right, any closing comments?
Someday, Mr. Chair, we will make it so these folks can issue this without coming here, but that's my closing comment.
All right, perfect. With that, Senate File 623 will be laid over for possible inclusion.
Senator Howe, you have Senate File 3371. Would you like to move 3371 be discussed and laid over?
That is the motion, Mr. Chair.
And to Senate File 3371, Senator Howe.
Thank you, Mr. Chair. And 3371, basically all it does is allows a temporary license that a municipality can issue, a 1 to 7 day temporary license to basically a county fair, so a county agricultural society. So basically, it just allows the city to issue a 7-day permit to the county fair. And that is the bill.
Well, thank you, Senator Howe. Members, any questions? Members, any questions? Seeing none, Senator Howe, Senate File 3371 will be laid over. Thank you. And we have Senator Rosen should be here in just a minute. Senator Rosen, welcome to the committee.
I'll take it.
Well, welcome to the Commerce and Consumer Protection Finance and Policy Committee. Senator Rosen, you have Senate File 2922. Senator Eichhorn, would you like to move that Senate File 2922 be brought up for discussion and laid over?
Yes, Mr. Chair, I'll move that Senate File 2920 be brought up for discussion and laid over.
Senator Eichhorn moves Senate File 2920 be brought up for discussion and laid over. Senator Rosen, whenever you're ready, please go to your bill.
Thank you, Mr. Chair, and thank you so much for this opportunity. I have never been before you. I think it's been a long time since I've had something to do with liquor, Pemberton, actually. But the bill before you, 2920, actually, we need to have an amendment, the A1 amendment adopted, and I believe that hopefully is in front of you.
Yes, we have the A1 amendment. Senator Howe, would you pass the A1 amendment?
So moved.
Senator Rosen, is the A1 amendment, is it a delete all to get your bill
No,
in
Mr.
order?
Chair, it just fix up the bill before you because it doesn't quite get to the situation that we have in Madelia. Madelia wants to, they have a wine bar, and they would like to be able to sell do some off-sale wine. And this, the original bill, says produced by the winery. Well, originally, they were gonna bring some wine in from Oregon, and that didn't work, so now they're bringing wine in from Lanesboro, Four Daughters, I believe it is. And so they just wanna do an off-sale there. I do have Brent Christensen on the line, I believe he should be on the line. And
Okay,
he's with
before
the.
we do that, Senator Rosen, we'll vote on the A1 amendment. All those in favor of the A1 amendment, please signify by saying yes.
Aye.
Opposed, nay. Motion carries. The amendment carries. Senator Rosen, we will see if Mr. Brent Christensen is with us. He is. Good afternoon, Brent. How are you? Or good evening, I should say. How are you today?
Very well, sir. Thank you. Good evening, Mr. Chairman and members. For the record, my name is Brent Christensen, and I'm here tonight as the president and CEO of Christensen Communications Company, a family-owned broadband provider headquartered in Madelia. Among other things, Christensen Communications operates the Madelia Area Redevelopment Corporation, or MARC. MARC is jointly funded by my company in Whatcom County. and charged with economic development for the eastern half of our county. And I'm here tonight to support Senate Bill 2920. Madelia, or Big Delia as I like to call it, is a vibrant community of just over 2,300, located halfway between Minneapolis and Sioux Falls. I know everyone in greater Minnesota thinks that their town is special and unique, but ours truly is. We have amazing entrepreneurs pretty much everywhere you turn. The vast majority of our businesses are locally owned, and the collaborative spirit is truly inspiring. On any given Friday or Saturday night, it can take up to 40 minutes to get a table at La Plaza Fiesta, our Mexican restaurant. But that's okay, because you can go across the street and have a locally brewed beer at Lost Sanity Brewing while you wait. Or you could just go straight to Lost Sanity and order a pizza from Fox's Pizza Den, who will deliver it to the brewery. You can do all of that before going to see a first-run movie at Madelia Theater. You get the point. We work together in Madelia, and everyone wins. Recently, a wine bar opened on Main Street. And the problem that we have is that they can sell glasses of wine in their establishment, but unlike wineries, if you like what you have there, you can't buy a bottle from them and take it home. This bill would fix that problem. We have worked to tighten up the language in the bill to only apply to off-sale of wines that are available for consumption on the premises. This bill would allow the new wine bar to have the same capability as our brewery and make our community an even larger social destination. Thank you, Mr. Chairman, for the opportunity to testify tonight. And with that, I'm very happy to stand for questions.
Well, thank you, sir. And members, any questions for Mr. Christensen or for Senator Rosen? Members, any questions? Seeing none, Senator Rosen, Senator Eichhorn, would you renew your bill or your motion to?
So moved, Mr. Chair.
Senator Eichhorn moves that Senate File 2920 be discussed and laid on the table, and so shall be. So thank you, Senator Rosen.
Thank you very much, Mr. Chair, and thank you, members. And remember, all roads lead to Madelia. It's kind of serious. Thank you.
Senator Dahms, to your bill, Senate File 3288.
Well, thank you, Mr. Chair, and I move that Senate File 3288 be considered and re-referred to general orders. To the bill, Mr. Chair. Senate File 3288 is a bill that deals with proctors and in mostly the insurance education realm, but it's in the education realm that's managed by the Department of Commerce. And I do believe that Peter Brickwoody has joined us by Zoom. And so if Peter is with us on Zoom, if he would like to discuss the bill some, I certainly would appreciate it.
Commissioner Brickwoody, would you please state your name and continue with your testimony?
Mr. Chairman, for the record, Peter Brickwoody, Assistant Commissioner from the Commerce Department. My apologies for not being there in person this evening. As similar to some other testifiers this evening, you may be able to hear my children in the background. Apologies for being away. Thank you to the chair for carrying this bill. It is a department initiative. The specific language of the bill as introduced is an attempt to resolve some confusion that we had seen in the marketplace for particularly pre-licensed education students who needed to take a test to complete their pre-licensed education prior to taking the state licensing exam. And there was some confusion, particularly in the early stages of the pandemic, where people were primarily doing this remotely, about who a disinterested third party with no conflict of interest is, as defined in the current law in Chapter 45, which members can see in the bill. So our attempt here is to clarify without changing anything about the existing requirement, but to make it a little bit easier to understand. I will say that there is, I think, an amendment that we would like to continue to discuss, and we'll continue to work with the chair on that, which has a specific impact on this language as introduced, as well as a broader group of initiatives that we, along with a number of stakeholders from across all of the industries that have continuing education requirements at the department, have been discussing for the last several months. But we'll continue to work with the chair and appreciate that he is moving the bill forward while we can have those conversations. So happy to answer questions to this specific language, Mr. Chair, and I'll yield back.
Thank you, Mr. Brickwoody. And any questions from the committee? Seeing none, final comments, Mr. Chair?
Commissioner Mr. Brickwoody did refer to an amendment. There is an A1 amendment. The reason I didn't introduce that amendment tonight is there are a few things that we have some questions on. We want to make sure that the amendment is in the order we want it. So we got some time now before general orders that we can get that stuff worked out, and then we can put the amendment on when we get to the floor. So that's the purpose of that. But other than that, I have no other comments. So thank you, Mr. Chair.
Seeing no other comments, Senator Dahms renews his motion for Senate File 3288 to be sent to general orders. All those in favor signify by saying aye.
Aye.
Those opposed, nay. Motion carries. Senate File 3288 is on its way to general orders. Senator Dahms, Senate File 4191, to your bill.
Thank you, Mr. Chair, and I would move that Senate File 4191 be considered and re-referred to general orders. And with that said, this is a file that deals with the franchise laws of the state of Minnesota dealing with the automobile franchises. And what this bill does is it adds the franchise language to be extended to electric vehicles. So with that said, Mr. Chair, we do have some testifiers, both that support the bill and both that have some questions and don't necessarily support the bill. So if we could start with having a representative from MADA come up, I would appreciate it.
Ms. Backus, could you please state your name for the record and proceed with your testimony?
Great, thank you, Mr. Chair and members. My name is Amber Backus. I'm Vice President of Public Affairs with the Minnesota Automobile Dealers Association, representing 375 franchise new car and truck dealers located across the state. And we appreciate Chair Dahms for bringing this bill forward. It caught us off guard because earlier this month, the entire industry was surprised when Ford announced it would be splitting its electric vehicle and internal combustion vehicle operations into separate businesses. Within the following days, Honda announced it would be partnering with Sony to form a wholly new automobile manufacturing company to sell EVs. What this means for their distribution networks, the franchise new car dealers who take on the costs and risks of selling the vehicles to consumers, has yet to be seen. Ford's executives have committed to working with their dealer network during this transition, and we're grateful for that. But as corporate executives come and go, we want to make sure our dealers have more than promises to keep them in business. Upon hearing of these announcements, we did an immediate review of our Minnesota statutes, Chapter 80E, which governs the relationship between dealers and their manufacturers to safeguard that Minnesota dealers would be protected as these new businesses come to life. And we learned two things. One, we have a loophole in our law that allows the manufacturers, at their sole discretion, to make alternative fuel vehicles defined as those that run on natural gas, liquefied petroleum gas, biofuels, electricity, and other alcohols, to make those only available to select dealers, not all of them. Current law requires manufacturers to make all gas and diesel-powered vehicle models within a line make available to all dealers. This law was intended to protect dealers from manufacturer abuses of picking winners and losers within the manufacturer's franchise dealer network. The same sound reasoning of this 20-year-old law should extend to all types of vehicles within a line make, including electric vehicles. We also discovered that these new businesses announced by Ford and Honda, which are effectively the same as the legacy manufacturers that are subject to the longstanding non-compete protections within ADE, Minnesota's dealer franchise law, may be allowed to compete directly with their existing franchise dealers. Such competition flies in the face of the spirit and intent of the current law. In order to shore up this potential loophole, we seek to expand the definition of manufacturer to include these new businesses that are directly or indirectly owned or controlled by current manufacturers to ensure they do not circumvent the intended protections of the motor vehicle franchise law. And the bill before you reflects these changes and is absolutely critical to the long-term success of our Minnesota dealers. Closing the loophole on alternative vehicles is especially important now. Minnesota is under the regulations of California cars, and we don't want the burden of taking electric vehicles from the manufacturer in order to comply with the supply mandate to fall on only some dealers. This means a handful of dealers could be stuck with excess electric vehicle inventory well beyond where consumer demand is, making them less competitive than their peers who may not have to take any EV inventory. And in the long term, we don't want dealers who have been designated as legacy internal combustion vehicle dealers to no longer have access to inventory as the California rule and manufacturers transition to 100% electric vehicles. While we wait for the market to decide what the ultimate fate of electric vehicles will be, the advent itself of widespread electric vehicles cannot be used as a mechanism to bypass long-standing franchise laws that have historically been essential to safeguarding the viability of hundreds of small businesses across the state. It shouldn't matter whether a vehicle is electric or has an internal combustion engine. We want all dealers to have access to all of the models in their line make. It shouldn't matter that a current manufacturer created a new corporate entity. They should not be allowed to compete with their existing dealers under the guise of claiming to be separate from the legacy manufacturer. Passage of this bill is essential for dealers to continue to provide good-paying jobs, support charitable events in their communities, and thrive for the next 100 years, just as they have for the last 100. Thank you very much, and I'd be happy to take any questions.
Thank you. Thank you for your testimony. Next, we'll go to Mr. Bright with Alliance for Automotive Innovation. Please state your name for the record and continue with your testimony.
Thank you, Mr. Chair. My name is David Bright. I'm a senior attorney with the Alliance for Automotive Innovation. We're a trade association that represents car manufacturers as well as Tier 1 suppliers. We're opposed to this bill as introduced. However, I am confident that we can negotiate language with the State Dealer Association on the bill, and we've already reached out to the dealers to discuss scheduling a call for next week. Briefly, my concern with this bill is that it could cause problems for manufacturers that have multiple brands that they sell, either now or new brands in the future. And it could also discourage manufacturers from pursuing joint ventures with other manufacturers, which has been a common practice in the automotive industry for several years. Again, I don't think it's the intent of the bill to frustrate those efforts, which is why, as I said, I am confident that we can negotiate a compromise on this bill. We'll be happy to keep the committee informed if you would like. Having said that, I don't want to take up too much of your time this evening, so I will thank you for the opportunity to speak and be happy to answer any questions.
Thank you for your testimony. Any questions from members? Senator Kent.
Thank you, Mr. Chair. Senator Dahms, just based on that testimony, are you open to working to make sure that this is workable moving forward?
Oh, absolutely.
Senator
There's
Dahms.
been a couple of things brought up already, Senator Kent, excuse me, that have been talked about. And I think that there's, they're working on those, and I feel confident those will get, certainly that'll get taken care of. I feel pretty confident by the time we get the bill to the general orders, that it'll be in the shape that everybody can live with. We need to be open-minded about this, and we need to work together to make this happen. And so far, what I'm seeing the indication on both sides that they're willing to come to the table and work this out. And I think the key to getting a lot of this stuff done is when people come to the table and show their, talk about their indifferences and how that's going to affect each party and stuff, and then work it out from there. So I certainly will encourage them to work together, and I don't see this to be a problem, quite frankly.
Thank you.
Yep.
Anyone else? Seeing none, Senator Dahms, final comments.
Well, I think that this is a bill that is fitting at this point in time, and I think it's early enough as far as in this process when it comes to introducing electrical vehicles and stuff. I think it's early in the process enough so that we can give some of these dealers that have been around for many, many years, give them the feeling that there's going to be some stability there. As I remember, the requirements are going to be for the dealers that there's going to be a percentage of the new cars that are sold are going to have to be electric vehicles. So if you do not have access to electric vehicles as a legacy dealer, it's going to be pretty hard to meet those standards, because basically if you don't have electric cars to sell, it's going to put you out of business on the gas automobiles too, because you won't be able to meet those standards. Now, I don't know if that'll end up being that way once we get further into this, but at this point, that's the understanding I have of the bill with the California emissions and the California cars. So I think it's important that we address it now. So with that said, I would appreciate the support on the bill, and I will renew my motion.
Senator Dahms renews his motion that Senate File 4191 is passed and re-referred to the general orders. All those in favor signify by saying aye.
Aye.
Those opposed, nay. Motion carries. Senate File 4191 is on its way to general orders. Seeing no other business in front of the committee.
Mr. Chair.
Senator Kent.
A quick question, just based on this evening. Senator Dahms, are with these liquor bills laid over, are we looking at a liquor omnibus bill, or what is?
Haven't made that decision yet. Thank you.
Thank you.
Senator Port.
Thank you. Mr. Chair, also just wondering what the, sort of long-term plans for this committee are. There's some, consumer protection and price gouging bills that I would love to, have discussed in this committee. Is there any possibility for that? Are we, through with our work here for the session? What is the long-term plan for this committee?
We will, thank you, Mr. Chair and Senator Port. We will have probably one more meeting, very likely next Monday, and that'll be to take care of a few odds and ends that we have out there that we need to clean up. And then probably 2 to 3 weeks later, we'll have an informational hearing on the bill that was just introduced today. Well, it'll actually be introduced, I think, tomorrow. And that's the bill that we're working with both the fuel petroleum folks and the ethanol folks. And there's now we're getting close to having some agreements there. So it'll be an informational hearing because of the deadlines and stuff. But that's where we'll be going in the next couple of weeks. So, and then that'll wrap it up unless something else comes up that needs to be dealt with when we get further down the line in the second and third end here. Yep. Deadlines. Thank you for the
No
question.
other questions, and taking care of all the things on the agenda, this meeting stands adjourned.